Are there any applications?
Yes, Your Honor.
Okay. Court is calling 2025 CR 009906, State versus Timothy Wald. Could I have parties announced?
Pertaining to the state of Texas.
Alday Smith for the defense.
All right, Mr. Wald. And are you Mr. Wald?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I have, and we did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Wald, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
All right, off the record. The box is checked that the
This case already shows how fast a routine courtroom plea can turn into something much deeper. By this point, the judge has already confirmed paperwork, clarified rights, and placed the defendant under oath, creating a foundation that sets the tone for what's ahead. Even though everything seems procedural, the tension is building underneath. A third-degree felony is serious, and you can feel the pressure closing in as every question forces the defendant to acknowledge the reality of his situation. This is the moment where viewers should lean in, because major shifts in the judge's tone are about to happen.
state is recommending deferred adjudication?
Yes, ma'am.
All right, I need an application for deferred adjudication.
I thought
No, it's just for, you just did an application for community supervision.
I don't know if you have a second one.
I had both of them on there.
Yeah, I grabbed it. I thought it was non-jury.
Yes. Did you review the true bill? We're back on the record. Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the
Now the energy changes dramatically. The judge cuts through the excuses and goes straight to the heart of the issue, a confrontation involving a 14-year-old. The defendant's explanation feels shaky, but the police report tells a much stronger story, neighbors stepping in to protect someone they believed was in danger. When third-party witnesses get involved voluntarily, especially to shield a minor, you know the situation was disturbing enough to raise serious alarms. This is the turning point where the defendant's credibility begins to crack, and the judge's focus becomes razor-sharp.
indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with injury to a child or elderly or disabled person, bodily injury as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained.
Here's where things become very real. The judge lays out strict terms for deferred adjudication, employment requirements, no contact orders, drug testing, parenting classes, anger management, and community service. These conditions are not optional. They are legally enforceable and closely monitored. Violating even one can instantly activate the full 2 to 10-year prison sentence. Deferred adjudication is both mercy and warning. It offers a second chance while holding a fully loaded consequence behind it. This is the court giving him one final structured opportunity to turn things around.
For the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes.
You're going to need to speak up.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
As the hearing ends, the judge emphasizes personal responsibility. 7 years of deferred adjudication means the defendant avoids a felony conviction, but only if he follows every rule perfectly. With children depending on him and the threat of a 10-year sentence hovering over any mistake, the judge makes it clear. This is his last chance to make better choices. This case shows how quickly domestic conflict can become a legal crisis and how seriously courts take the involvement of minors. If you found this breakdown eye-opening, make sure to like, comment, and subscribe for more courtroom analysis and real case insights.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
My opinion, yes.
Mr. Wald, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything? Other defenses that the plea knowingly and voluntarily waived and
Your Honor, we'd ask that you follow the Reed recommendation.
are you still with Miranda de Hoyos? All right. Why are you fighting a 14-year-old?
So I actually, yes, I had an altercation with, there's two neighbors out there. There's an adult and I guess there's a child as well.
Well, what they're saying is that you were having an altercation with Miranda, who you're no longer with. That's what the police report says.
Right. So basically I got locked out of my house and that was my girlfriend at the time. And so I was basically beating on the door to get in. And, the neighbors, I guess, commented on me beating on the door. And so they basically started an altercation with me
Let me ask you this.
on my doorstep.
Were you on the lease?
No.
So that's not your place.
Well, I was living there for 2 years.
Yeah. But here's the thing. Obviously, she didn't want you anymore because it says that you got in an altercation with her. And then the complainant and his mother were just trying to help her. And the 14-year-old asked Miranda, hey, do you want me to stay here or you want me to leave? And she said she wanted him to stay. That's what's in the police report, what you stipulated to. So it appears that Miranda did not want you anymore, that you got upset by it. The neighbors thought she was in danger. So that's why the neighbors got involved. So it wasn't these neighbors just like, oh, let me come on your doorstep. They were on your doorstep because they felt that Miranda needed protection. Are you employed?
No.
So how do you support yourself?
Well, I now going through it too.
At this point in the hearing, the tone becomes noticeably more serious as the judge prepares to lay out the final conditions of the deferred adjudication. By now, it's clear she's not just issuing a sentence. She's issuing a warning. Everything she lists is intentional: employment verification, no contact restrictions, mandatory classes, drug testing, and community service. Each requirement is designed to reshape behavior and prevent another dangerous situation. This is the moment where the weight of the consequences truly hits. The message is unmistakable. Follow the rules or face the full 10-year sentence. And viewers, ask yourselves, will he take this second chance seriously?
Agency to work.
So how do you support yourself?
I haven't been
So where do you live?
staying with my kid's mother.
All right. This is what the court is going to do. There's 7 years deferred adjudication. There's going to be proof of employment within 45 days. No employment as a home health care provider or with minors. There should be no contact with the following persons: regular reporting by Zoom or in person, regular random UAs, field visits 1 time per month until further notice, 200 hours community service restitution. I'm going to order parenting classes. Once that's completed, 100 hours will be deemed satisfied. The remaining 100 hours will be deemed satisfied upon completion of anger management. There should be a TAP evaluation, out of custody, follow TAP results. There should be a $1,500 fine, and that will be probated. Probation, is there anything else?
Okay.
Is there anything else you need from the court in order to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because there was no affirmative finding. All right, we can go off the record. Here's the thing. You're going to have to make better decisions. You have children who are depending on you. If you don't make good decisions, what's going to end up happening is you're potentially looking at 10 years in the prison. Do you understand? All right, good luck to you.
Thank you.
Okay, your P number, counsel?
35262.
Okay, counsel, do you have a tie on?
No, I forgot. I'll go get, you want to pass the matter and I'll go put one on? I forgot.
Counsel, I'm just slightly confused. You're in court. I'm not sure how as an attorney you forget to have a tie on.
I understand. I'll just go do it.
Do you have your suit jacket as well, or what?
I think so. Yes.
Yes, counsel, that's an expectation of the court. Absolutely.
I'll go see if I have a coat and tie. I'm sorry, Your Honor.
We're on the record in the matter of Mike Vigilante versus Rachel Duncan, 250.